Let me start with the criminal liability. When I talk about criminal liability in medical practice, the worst scenario which my doctor faces is a death on table. Death on table happens, like I have given example that you're given a local anesthesia, patient got anaphylactic shock and patient died, or post-treatment of your patient got septicemia and died, or patient got blood loss, patient was an INR or hypertension, you're not aware about that. And then naturally, patient died because of some complication later. What maximum can happen? I'll tell you what maximum can happen is a section 304A of IPC. Now, what this 304A of IPC says? It says causing a death without intention, because you're not having an intention to cause a death. So causing a death without intention with negligent act. And same section applies to driver also. While driving, if at all someone comes and driver kills that guy, the intention is not there, but guy has got killed. Negligence of driving was proven. And then section 304A. But not to worry, my friend, because 304 is not deadly section, because it attacks 0 to 2 years punishment maximum, and bailable offense means you can get a bail on the spot. So not to worry about that section. So 304A in a live patient where you cause the pain, or where patient is not happy with the treatment, yet they can go to the court of law. There the complaint can be registered under 336 or 337, majoritarily 338, because 337, 38 talks about the grievous injury, and tooth being a part of the body. If tooth has broken and removed, it is like a fracture. So it comes under grievous injury again. Either it will be 0 to 6 month punishment or 0 to 2 years, things are same. No, not to worry about that. Honorable Supreme Court came and intervened to protect professionals. And Honorable Supreme Court has very well defined and interpreted the section 304A in respect to the driver and in respect to the professionals, because same section applies to both the people. The Honorable Supreme Court has said that with fearful mind, with a fearful scenario, and with a traveling hand, surgeon cannot do surgery. And fearful means the fear of law. So they need to be protected under the law. And hence, Honorable Supreme Court has formed a guideline saying that medical science is not an exact, being an exact science, and medical science being an expert science. We can't expect educate judges, police authorities, or complainant to know about the medical science. Hence, to fasten a criminal liability against the doctor, it must be referred to the expert for opinion. So when they have made a guidelines, means even if at all death happens on your table, you're not going to get arrested on the spot. So there's no question that police can arrest you. What maximum police can do? They can refer it to expert for opinion. It will take 3 months, 6 months. If opinion comes, then they will be called. They call you, and it could be bailable offense. You get a bail immediately. So never ever get terrified even if patient dies. You're not intentionally causing a death. Yes, Honorable Supreme Court is very clear what it said. Medical science is a complex science, and human body is a complex machine, which is beyond imagination of medical practitioner. Hence, to fasten criminal liability, we need to see the parameters. And they said if due care is given, then you are safeguarded. Due care means if you have recognized the complication and acted to save the life of the patient, then you are absolutely clear, because you being a doctor, court expects you to provide your knowledge even in a complication. And that's the reason why defining 304A for driver and 304A for doctor, Honorable Supreme Court has said that to fasten a criminal liability against the doctor, the negligence must be gross. When they've used gross word, it means that it can be seen from the eyes. Mop left inside the abdomen post-surgery, or doing something, instead of left, right, amputate, which can be seen from the eyes. So much degree of negligence are expected by the court. So simple medical negligence, you are not been bothered. Every simple medical negligence, even court says will go to civil court, where compensation will be awarded to the patient, but no jail punishment to the doctor. So beautiful law, my friend. But yes, let me caution you when I talk about 304 plain. In last 4-5 years, it was my experience that majority of time, the interpretation done by the police prosecutor or the advocates about the law, about the sections, are a different way altogether. When I talk about 304 plain, which says causing a death without intention, with the knowledge. The word inserted in the definition is with the knowledge that particular thing can lead to death. Changes whole scenario of the section, and now this section becomes non-bailable, 10 years punishment. So you need to be very careful, my friend. I'll give example of Salman Khan's, where while driving, 7 people got killed. He got bail on the spot. But later, when deposition done by the constable that he was drunk and drive, the component of knowledge came. Drunk and drive means knowledge that I am in influence of alcohol, and he killed 7 people, got converted to 10 years punishment. So that same happened in medical practice. Let me give you 1 or 2 examples to make understand. There was a case where tooth extraction was done by my doctor. In spite of knowing that patient was suffering from diabetes and hypertension, he continued the treatment without doing basic investigation. Patient went to septicemia because her diabetes was little, examined and found to be a 500 plus, and in septicemia she died. And the prosecutor has interpreted the doctor was having a knowledge that without doing basic blood sugar, without controlling the diabetes, I am proceeding with the surgery and there's a high chance of septicemia, and septicemia has happened, the patient died. 10 years punishment, non-bailable offense, and can be termed as gross also, my friend. So we need to be very careful. I have got a case where patient died due to bleeding because patient was having hypertension, patient was on INR, and implant was done on a patient. Patient got admitted to tertiary care center, bleeded, and ultimately died. Even if that can be interpreted today, it can be interpreted with a different angle altogether. So 304, you need to be very careful. My advice to all practicing doctor here, please do basic investigation prior to any procedure you adopt on patient. And you are there in procedure only. Try to understand. 90% time you are maybe doing a procedure. Conservative treatment is hardly be there. It could be tooth cleaning, or it could be tooth extraction, it could be RCT, it could be implant, it could be any treatment you are giving to the patient, bridging or whatever you do. Everywhere procedure comes. And then basic investigation like CBC, blood sugar can save you a lot, my friend. So 304, try to avoid that, because that knowledge can, and then naturally backup facility in every dental clinic. Backup means some emergency drugs, some emergency arrangement, because court expects that when you are giving a local anesthesia, having a knowledge that can happen, have you got all equipment ready to safeguard patient in emergency. That will also help you to reduce the section against you or safeguard you. But at the same time, the Honorable Supreme Court said that we are protecting doctors for criminal liability, but does not mean that patients should suffer. And they said, for every simple medical negligence, it is actionable under civil law. When I talk about civil law, in our country, we are witnessing Consumer Protection Act 2019, well transformed act. And let me tell you, it is Consumer Side Act. Everything has been put by Parliament to make this law consumer friendly. And we are governed by this law as a service provider. And of course, in civil court, law of torts. So here we need to be very careful.